In this next portion of the seminar is dealing with the question of documents, and the question is how do you deal with documents in a court action, particularly in the small claims court. When you want to prove your position, there are basically two ways in which you prove your position in the court in evidence. The evidence is either documents or the viva voce evidence, which is what you say verbally under oath in the courtroom. Now, therefore, the document preparation is a very important part of an action, both for the plaintiff as well as the defendant. So where do you begin in terms of assembly of the documents? And I can tell you my approach is that a good way to deal with a legal file is to create a working memorandum. So you know in your mind the different issues that you're going to deal with, and then you are putting your mind into creating the information on the evidence that you'll provide to show and prove your position in the court. So in the small claims court, the rules are a little bit more relaxed with respect to the evidence. In the pleadings, you're not required to write all the detailed evidence. You don't need to write and say that all these things in a story format happen. You have the opportunity to prove your position through documents and the evidence, and it's important to know how much to say in the pleading and how much to say through the documents. So the next point in terms of the evidence gathering and assembly of the documents is trying to figure out, in your case, what is the documentation that you will need to prove your position. So as a good example of that arrangement is the business documents. If you were, for example, you bought something and there's a Visa card that you used, the Visa made a notation that you bought a particular item, and therefore that item was recorded, you paid for it, you wrote a check and a receipt. These documents create evidence, and there is a general rule of how you can use a business record as a way to prove the record in a rather document in the court. So any document that is created in the normal course of the events in most transactions create a very valuable record of the event from the evidence point of view. Most important part, for example, in a contract is the document itself that creates the contract. So that's why lawyers sit down in complicated contracts and write out the things in great detail. But sometimes a contract can also be made verbally. Your man who comes to repair your basement is in fact engaged in the process of a legal contract to say, I will provide the service, I'll render the service, and I'll charge you a certain amount of money. That is a contract. But if you had to debate that in the courtroom, you need tangible evidence as to what the conversation was about, and does it fulfill the obligations of the law of contract in terms of consideration, the parties, the service to be rendered, etc. So it's very important for the lawyer, the paralegal, and people dealing with or if you self-represented when you go to the courtroom, what is the document that you can rely upon? So as a habit, if you are just a person that does things, it's a very good idea to document and record what different things you're doing, and that forms your part of your record of the agreements that you make or the documents you can use if something went out of line and you had to go to court. For the lawyers and paralegals, they have to identify from their knowledge and experience and tell the client to create the list of documents that are important for your transaction in which you're going to court. So you create the list, and some of the list of what you create can be in the format of a checklist, if you like, of the documents that you would do, and then use the documentation, exchange it with the client approves the documents, and you should ask him to create his own file where he keeps the documents, and you have a second copy. Because one of the things that is not written in the rules, which you'll come across in your daily practice, is a question I gave you to you, Mr. Lawyer or Mr. Paralegal, and you don't have it in the file. In that time, I recommend strongly that as a lawyer or paralegal, that you tell the client to have his own file, which you should bring to each meeting. But in the days of computer, this problem is being solved by keeping the document on the screen in a Dropbox or Google Drive, where everyone dealing with the file with confidentiality that you have to observe is able to look at this document. But coming back to the original issue, what documents do you assemble and what documents do you need? So you should be very relevant and to the point. It's a process of judgment in your mind that you will collect the documentation that is relevant for the purpose of the action that you're going to prove. So let me just take one example that I'm dealing with right now, that we have a porch that somebody didn't repair properly. So what would you show? Firstly, an agreement that the porch was to be repaired. Secondly, the evidence of repair through a repair company that said, I charged you a certain amount of money, and his invoice. So these bits of evidence are objective pieces of evidence that you are using to show to the court that certain event did happen and there was certain cost attached to that one, and all the assembly of the facts that you want to bring across are more, in my words, tangible, effective, and there are rules which you have to observe to make sure that they are admissible, and once they are admissible, it creates and recreates a story that you want to present to the court. So essentially what I'm saying is that the document preparation in a litigation file is extremely, extremely important. There's a certain amount of judgment and skill involved in the part of the lawyer and the paralegal to determine what is relevant. And you can begin to assemble this documentation and present this in several formats, and there are procedures for that. And the small claims court will even allow you to attach certain documents right in the claim itself. Or you can do that also in the defense. That helps you to clarify your position right up front and saves you doing the assembly of documents later on. But you're not obliged to do that. You can do the document assembly later on, and you're required to bring this document to the attention of the court in a settlement hearing just 15 days prior. And if you're going to trial, 30 days prior to the trial itself. Sometimes the judge will order in a motion that the document be produced, and in a small claims court, you can use certain procedures more actively to try to obtain the documentation and then ask the other party that you want certain documents, and if they're not provided to you, you can ask for them in a settlement hearing. So the procedures in the small claims court are much simpler, but it is very important that you have an idea in your mind what documents you will require to prove a possession. Sometimes the documents are not in your possession. So if they're not in the possession of the other party, then you can request that, you can ask for it, but most importantly, identify in your own mind what is it that you will require, what is it that can be in existence, and what is it that you would want so that you can prove your position at trial. So I think that having said all that, I don't want to suggest that the evidence that you're going to present under oath in the courtroom is less important. In fact, the whole trial, the time of the trial will be conducted on essentially two things: evidence which is not hearsay and evidence which is documentation, and these put together in the proper sequence and order will determine and make up your case before the judge. So I think the main point that I'm saying is that the document preparation is a very important part of the way that you will assemble the documentation or the issues in your file and present them at the right stages in the court.